Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. That is the text of the First Amendment. Fun facts about the First Amendment. While almost every American has heard of the First Amendment, and most say it's vital, there are some surprising things most people don't know about it. For example, fewer than 1 in 10 Americans can actually name all 5 freedoms it protects. So let's go through them. Religion, speech, the press, assembly, and petition. And here's another key fact. The First Amendment protects those rights only from government interference, not from private people or companies. According to the Freedom Forum, which promotes understanding of the First Amendment, there are some fascinating historical quirks most people never heard about, including me. For instance, the First Amendment wasn't even first. It was originally the Third Amendment proposed. The first 2 dealt with congressional pay and representation, one of which finally became the 27th Amendment in 1992. Even more surprising, the First Amendment didn't even exist for the first 15 years of the United States' existence. It wasn't ratified until 1791, well after the Constitution itself was ratified in 1787. And it didn't appear in a Supreme Court case until 1821, nearly 3 decades later. So when we call it the First Amendment, it's not because it was seen as the most important at that time, but because history, irony, and a bit of luck made it number 1. The First Amendment is under assault in America. After the murder of conservative activist Charlie Kirk, officials have begun talking about punishing so-called hate speech. At the same time, late-night hosts Stephen Colbert and Jimmy Kimmel have been canceled and paused for their comedic political commentary. And artists funded by the National Endowment for the Arts now face political pressure over what they might say or cannot say about gender identity. Different sides of the spectrum, different targets, but the same fundamental question remains. What does the First Amendment actually protect, and why does it matter so deeply for our democracy? In 1651, philosopher Thomas Hobbes wrote, "A private man has always the liberty, because thought is free, to believe or not to believe in his heart." It was a radical idea then, so radical that Hobbes didn't feel safe publishing it in England. He published it in France. And 41 years after Hobbes wrote that piece, in 1692, my own 8x8 grandmother, Mary Esty, was hanged as a witch in Salem, Massachusetts, though she was innocent. Before her execution, she wrote to the petition of the Court of Oyer and Terminer, to the honorable judge and bench now sitting in the judiciary in Salem, and the reverend ministers, "I know not the least thing of witchcraft, therefore I dare not belie my own soul. I beg your honors not to deny this my humble petition for a poor dying innocent person." Her plea, a calm appeal to reason in an age of hysteria, echoes forward to one of the 5 fundamental liberties of the First Amendment, to petition the government for redress of grievances. The tragedy of Salem, driven by Puritan ministers like Cotton Mather, became a warning. When religion dictates law, justice dies. The framers of the Constitution understood that danger, and that's why the First Amendment begins, "Congress shall make no law respecting an establishment of religion." Centuries later, the tension between free thought and social control remains. International bodies such as the United Nations and the Council of Europe treat speech as a legal category, punishable by fines or even prison. Specifically, the United Nations seeks to limit hate speech. This runs counter to the United States Supreme Court's interpretation of the First Amendment, which allows for a much broader protection of offensive and hateful speech. In the UK, The Economist reports that police now spend thousands of hours scanning social media and arrest more than 30 people a day for posts deemed grossly offensive under the Online Safety Act. The Financial Times warns that Britain's police risk becoming thought police without a clear line between the criminal and the merely offensive. The UK now arrests more people for what people say online than any nation on earth, including Iran and China. And new proposals, such as the so-called Brit card, which is a national digital ID system for internet access, could tighten that control even further. Meanwhile, the European Union is debating a proposal called ChatControl, formerly the Child Sex Abuse Regulation. It would require tech companies to scan every private message, photo, and video for illegal content. This client-side scanning would happen on your device, even inside encrypted apps, using AI to detect supposed signs of, quote, grooming. Supporters say it would protect children. Critics warn it would destroy privacy, breaking end-to-end encryption and turning every phone into a government surveillance device. The result? No privacy, no freedom of thought. In the United States, the First Amendment draws a hard line. The government cannot punish you just because of your words. Offensive, hateful, or even disturbing ideas remain protected. And that makes America an outlier among democracy. And it's why here, the line is clear. Offensive speech is not criminal. The foundational principle of First Amendment protection is rooted in Supreme Court history. In United States versus Swimmer in 1929, Justice Oliver Wendell Holmes, joined by Justice Brandeis, declared in dissent, if there is any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom for the thought that we hate. Nearly a century later in Matal versus Tam, 2017, Justice Samuel Alito reaffirmed Holmes's words. The proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought we hate. In 2011, the court protected Westboro Baptist Church protests and military funerals. Justice Stephen Breyer, concurring with Chief Justice Roberts, wrote, "Speech is powerful. It can stir people to action, move them to tears of both joy and sorrow, and inflict great pain. But we cannot react to that pain by punishing the speaker." Together, these rulings form the backbone of America's First Amendment tradition. Moments of crisis often tempt leaders to silence speech. That's when the First Amendment is tested most. After the killing of Charlie Kirk, President Trump and his Attorney General mused about punishing hate speech. The instinct to outlaw offensive words in a moment of grief is powerful, but restraint matters most then. Unless words cross into true threat of violence, they remain protected no matter how cruel they sound. Humor, too, is under pressure. Stephen Colbert and Jimmy Kimmel heirs to a long tradition of satirical provocation were abruptly canceled. Now, even though Jimmy Kimmel came back, that push against them remains. In America, from Mark Twain's wit to Saturday Night Live's Lapoons, humor has always poked at the powerful. If we go back to medieval courts, even jesters in their motley would say what no courtier dared, speaking dangerous truths under the cover of a joke. But silencing modern jesters risks closing off that same cultural safety valve. The arts also have come under fire. The White House recently leaned on the National Endowment for the Arts to avoid projects dealing with transgender identity. Unlike a network canceling a comedy show, this is government pressure on creative expression. And that strikes at the heart of the First Amendment. And we've been here before. In the 1990s, Congress threatened to defund art it called indecent. A decade earlier, Tipper Gore's Parents Music Resource Center pushed the music industry to slap parental advisory labels on albums. She denied it was censorship. Critics called it exactly that. From rock music to modern art, attempts to police culture have come from both left and right. And on campus, free speech controversies persist. The Trump administration has targeted Harvard and Columbia under the banner of fighting antisemitism, a move critics call a stretch. Legally, the distinction matters. Private universities like Harvard and Columbia are not bound by the First Amendment, while public universities are. Yet across higher education, most institutions claim to champion open debate, even as they enforce speech codes or free speech zones. That tension between preaching free expression and restricting it in practice has made universities a recurring flashpoint. Whether in politics, entertainment, art, or academia, the pattern is the same. Both sides reach for censorship when speech stings them. Yet the First Amendment was built for exactly those moments, to protect the words we despise, the jokes that unsettle, the art that provokes, and the commentary that feels cruel. In 1969, Brandenburg versus Ohio overturned the conviction of a Ku Klux Klan leader who urged racist revengeance and attacks on Jews. The court ruled that his rhetoric was protected unless it was both intended and likely to cause imminent lawless action or violence. And that standard was tested in 1977 when the American Nazi Party sought to march on Skokie, Illinois, a community with thousands of Holocaust survivors. Courts said that the march couldn't be blocked simply because it was offensive. Protecting even the most provocative and deeply offensive speech is what keeps the First Amendment strong. And in 2023, the court narrowed the definition of true threats, requiring proof that a speaker acted at least recklessly. In Counterman versus Colorado, Justice Kagan wrote the opinion for the court defining true threats, again with the standard being recklessness. It offers enough breathing space for protected speech. That higher bar shields hurtful but non-dangerous speech from prosecution. Together, these cases make the rule clear. Hateful or offensive speech is protected unless it directly incites imminent violence or poses a genuine threat. Now, with such broad freedom, there are limits to the First Amendment. The First Amendment's protection of speech is among the broadest in the world, but it is not absolute. The Supreme Court has carved out only a few narrow exceptions. The first is incitement. In Brandenburg versus Ohio from 1969, the court ruled that speech could only be punished if it is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Advocacy of violence in the abstract remains protected. Only speech meant to spark immediate violence loses protection. The second limitation is true threats. In Virginia versus Black from 2003, the court defined these statements where the speaker means to communicate a serious expression of an intent to commit an unlawful act of violence. And in 2023, the court raised the bar even higher, holding that prosecutors must prove the speaker acted at least recklessly, conspicuously disregarding a substantial risk that their words would be taken as violent. This ensures that edgy or offensive words aren't punished unless they cross into genuine threats. And a third category is defamation and libel. In the New York Times versus Sullivan from 1964, as Justice Brennan wrote, "We must consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials." That high bar ensures criticism of leaders. Even sharp or mistaken criticism isn't easily silenced through lawsuits, or it shouldn't be. We've now seen where the Trump administration has threatened lawsuits, and law firms and private media companies have settled versus fighting them in courts. Most lawyers say that these attempted lawsuits would have been thrown out in courts, but the burden of having to protect for those lawsuits was deemed to be too great by these private entities. And finally, the First Amendment applies only to government action. It doesn't prevent private institutions from setting their own rules. And that's why employers can fire someone for offensive speech, or networks can cancel a show. Those decisions may feel like censorship, but legally, experts say they fall outside the First Amendment. So, the limits are few: incitement, true threats, defamation, and government action. Everything else, even the speech we despise, remains protected. So why does all this matter? Because democracy doesn't survive on popular speech. It survives by protecting unpopular speech. If the First Amendment only covered the polite or the popular, it wouldn't be needed. The ideas we now celebrate often began as heresies. Galileo was condemned for suggesting that the earth revolved around the sun. Abolitionists were accused of destabilizing the republic when they demanded an end to slavery. Civil rights marchers in the 1960s were branded as agitators and threats to public order. And the same is true in art. Weirdly enough, Impressionism, now the crown jewel of French culture, was first rejected by the French Academy as crude and unfinished. But American collectors in a more open marketplace became its earliest champions. Today, while Paris's Musée d'Orsay holds the largest single collection of Impressionist art, the overwhelming majority of Impressionist works are in American hands. And just as in art, so in speech, what one generation calls offensive may in time become enduring. Justice Oliver Wendell Holmes reflected this in his famous 1919 dissent in Abrams versus the United States. The ultimate good desired is better reached by free trade in ideas. That the best test of truth is the power of the thought to get itself accepted in the competition of the market. Sounds kind of capitalist, doesn't it? Protecting free speech we despise is not a luxury. It is the engine of democratic competition. It keeps the debate open, forces ideas to engage, and ensures that citizens, not the state, decide what arguments will win. As we wrap this up, the instinct to silence speech comes from every direction. Left, right, politics, art, entertainment. But the First Amendment doesn't bend to our partisan frustrations. Its power is that it stands above them. It reminds us that free speech isn't about protecting the polite or the popular. It's about protecting the offensive, the unsettling, and even the hateful. Because if we only defend speech we agree with, we don't have free speech at all. And in that sense, what they say, without the freedom to offend, there is no freedom to dissent, and it's deeper than you think. And I will see you in the next episode.